And you're watching our live coverage of the Presidential Election Petition Tribunal's judgment in 3 momentous cases that are happening today. This is coming to you live from Lagos, but we're of course live in the courtroom in Abuja, Nigeria's Federal Capital Territory, as the PEPC reads its judgment in those 3 very important cases. I'm Tolulope, Adeleru-Balogun, and I'm not alone, as we are going to be with you throughout the judgment day.
As Tolu mentioned earlier, this is a very historical occasion we're witnessing, and our cameras are live in the courtroom in Abuja, where the Presidential Election Petition Tribunal judges are currently on a 15-minute recess. What do we know so far? The case that the court has listened to the prayers of the APM, or listed the prayers of the APM, and I believe on the issue of double nomination for candidates, it's been struck out as a pre-election matter. That's what we know. The judge said the only applicable provisions applicable to qualification and disqualification in an election petition are sections 137 and 131 and 137 of the Constitution of the Federal Republic of Nigeria. Therefore, thereby saying that the issue of double nomination is a pre-election matter. So that has been settled. There's still other areas to look at, and the prayers of the PDP and also the Labour Party will also be read out. But we're not here alone. We have a lawyer, a legal practitioner, to help make sense of all the technical jargons and all the happenings in the court this morning. We have Barrister Bashiru Badr, who's joined us live from Kano. Mr. Badr, good day to you, and thanks for joining us on the verdict.
Yeah, good morning.
All right, so we're also expecting Monday Ubani to join us at any moment. But Barrister, let's start with you. There's a roll call of people we know who are inside the courtroom, but as of right now, they are, of course, going to be outside on that recess as well. But to the merit of the case, the Allied People's Movement made a petition to the court. It was one of the petitions praying that the court dismiss, or rather nullify, President Tinubu's presidential victory because of the double nomination of his vice presidential candidate, Vice President Kashim Shettima. That has now been struck out. We heard things like no merit, liable to be struck out for being incompetent, also the conversation around the pre-election matters, no locus standi, incompetent for lack of locus standi as well, and a number of other things that a reminder that the court must limit itself to words used in the Constitution. So just on the face value of it, with this very first judgment in the first of the 3 cases we're expecting to hear judgment for today, what are your thoughts?
Yeah, thank you very much. It's the judgment day, and the verdict is being read. To common persons on the street, the implication of some of these words employed by the court is very, very significant to appreciate what the mind of the court is driving at. Foremost, when they say it is incompetent, meaning that whatever a petitioner or a claimant alleges or puts before the court weighs it on a particular scale. And what is that scale? Does it meet up with the requirement of the law? Is the position of if the claim has anything to do with established statutes like the Constitution or any other law? In this circumstance, the Constitution, the Electoral Act, and any other regulations, is it in tandem with the provisions of these laws? If it is not, then it is incompetent. It is incompetent. Now, locus standi is the ability of an individual to institute an action. Does he have that ability to institute an action under this circumstance? Does he have that capacity? If he has that capacity, the court will rule that he has a locus standi. But if he does not have the premises, he's a citizen, he has a right to litigate. But does he have a right under the provisions of the law to litigate? In that circumstance,
The answer will be no. If the law that provides for his ability to institute that action is not met, then he has no local standard. So a lot of languages like that are employed by the law, and these languages are carefully explained even by these same laws. So what the APM came to court to do is just to waste the time of court, especially in this circumstance, because what they came to ventilate before this tribunal is the case of double nomination of Shetima, so as to nullify the candidacy of President Bola Ahmed Tinubu. And 131 and 137, sections 131 and 137 are very clear about this issue. These are issues at pre-election matters. The pre-election matters are not often and usually taken
to the tribunal.
Post-electoral, when the tribunal is sitting, they don't look at it. They want this matter, they expected this matter to have been resolved before the election holds. And if it has not been resolved before the election holds, sorry, nobody goes there again.
Okay.
That is the law.
All right, Barrister Badr, thank you for that. I want to bring in Barrister Monday Ubani, solicitor and senior advocate of Nigeria, former chairman, section of public interest and development law, joining us now also on this conversation. And I want to pick up where Barrister Badr left off. The court has now ruled that this is a pre-election matter. And as he said, typically it doesn't make its way to the Presidential Election Petition Tribunal or even Governorship Tribunal, because we also know those are also holding as well. But given the fact that this case made it this far and has now been adjudicated, it has now been judged, should we be asking questions? Was it not something that we really should have seen possibly thrown out or dismissed in the early days of the sittings of the tribunal? Barrister Ubani.
Filed an election petition before the tribunal or the Court of Appeal, now acting as court of first instance for presidential election. You have to consider the petition on its merit. If you find out that the court had to rule on some of the interlocutory applications that were filed by both parties, and if you had published up at there, that matter would have been ended. But they need also to take it to full trial, because this is not the final court. The Supreme Court will have to examine what has actually been decided today. So, to answer your question, it wouldn't have been, wouldn't have ended at the interlocutory level, because it's a substantive petition that has been filed. You have to take the interlocutory applications, at the same time take the substantive trial. Well, what the court did now is, after taking the interlocutory application, the reserve ruling, which will be incorporated in the main judgment, which is actually what happened today. You can see that after doing all that they did, they say, since it's not the final court, let us go into the merit and also decide this. And they look at it, holistically. They say that, well, this matter is a pre-election issue and it's statute bad. And then the party that came to court has no locus. It can only be a party from the same political party who has contested the primary that could have even raised the issue of double nomination. But be that as it may, the court went into even the merit itself to look at whether, since they came under issue of qualification, which is one of the grounds of petition, whether this particular matter qualified as a disqualification factor for the president and for the vice president. And they found out that, looking at the constitutional provision as to qualification, there was no way issue of this nomination thing became a disqualifying factor to either the president or either of the vice president. So that is the case also decided on merit. So the position is that you wouldn't have ended it at the interlocutory level. You still have to go to the fuller level of hearing the full matter, which now has been laid to rest, both at the interlocutory and both at the substantive level.
Now, stay with you, Barrister Ubani. We've seen a situation where some of the parties have similar prayers. And for example, the issue of double nomination has been answered now. Does it mean that the judges, when it comes to listening to their prayers, would skip over it as if it attended to, or do they still have to go through the same process where you have similar prayers?
Yeah, to lessen the laborious nature of this judgment, whatever has been decided, which form part of the relief of the other parties now, they will take this now to be the judgment of the other parties also. So far, it is this relief of double nomination. The court now, whatever has been decided in this first petition, will apply mutatis mutandis now to the other parties who have raised this issue as a ground. You know, these are part of the issues to be decided. One is issue of this double nomination. Another is issue of 25% requirement for FCT. Another is issue of whether INEC comply with their own internal guidelines, you know, of transmitting the result to IREF is one of the things we are looking forward for consideration. Then the issue of President Bola Tinubu's drug case allegation and that of the certificate, and then the issue of his identity. All these are issues that we expect the court to resolve in other petitions that will be coming. But this one that has to do with the double nomination, from the look of things, have been decided, and so it applies to all other parties who may have raised it as a relief.
And so, as you said, there are a number of issues. Today, 3 cases are being judged in front of the Presidential Election Petition Court. And what we have is Mr. Peter Gregory Obi and Anor versus the Independent National Electoral Commission and others. Allied People's Movement has now received their judgment in this case. And then we also have Atiku Abubakar and Anor versus Independent National Electoral Commission and 2 others. So those are the cases to be determined. One has been determined as it is right now. So many of us are hunkering down for a long day. But Barrister Ubani, as you said, 25% in FCT has been a massive controversy from this election, of course, as well as the potential qualification or maybe lack thereof of the president. Barrister Badr, let me bring you in, because let's go back to the Constitution, which is what the justice referenced when he was reading the judgments. He said that the court must limit itself to words used in the Constitution, and that where the Constitution qualifies someone to run, no other law can disqualify them, and no feasible grounds for disqualification in what the APM brought before the tribunal. So when we look at that, and as you said, and Barrister Ubani has said as well, this is not the last court. The Supreme Court is ahead of us as well. Do you really think there's any potential merit in an appeal from the APM all the way to the Supreme Court?
Well, it is difficult for anybody now to say, oh, they cannot go further. No, everybody has a right to ventilate his grievances. If he's dissatisfied, if APM is dissatisfied with the position of the tribunal today, they still have opportunity of exploring whatever it is at the Supreme Court. That is the apex court. That's the court that will give the final verdict. But as it stands, you can't say whether, oh, because the Court of Appeal has said they don't have grant, they don't have that, they still have their right. If they feel that they have, the Court of Appeal has not done substantial justice to their claims, then they move upstairs. They still have that room. So it's too premature at this stage to say, oh, they don't have any other thing again to ventilate at the Supreme Court. They may have.
Let's go back to this issue of locus standi, because you raised it earlier, and what the court is saying, that given that this is a party that's not a petitioner, that's not part of the party, because of the terminology used, a petitioner that's not part of the party, they really cannot be involved in raising an issue of disqualification or double nomination, as it may be. But this issue of locus standi has been one that seems to be very controversial in the Nigerian judicial system. Some have said that any interested Nigerian in some situations should be able to have locus standi when it comes to issues of national interest. How do we sort of weigh the judgment that this tribunal has given us around some of the issues around locus standi that we've seen come up in recent times in Nigeria? Barrister Ubani, I'd like you to also take a stab at this as well.
You want me to go ahead now?
Let Barrister Badr go, and then I'll come to you, Barrister Ubani.
No, I actually lost you midway, so.
All right, so Barrister Ubani, if you heard my question, go ahead, and I think that Barrister Badr will pick up from there.
Yeah, what has happened with the issue of locus is that the Electoral Act itself has been amended in order now to limit the persons that can approach the court in case of any grievance on pre-election issues. You must be a candidate that have participated in the primary election with the candidate for which you are going to court against. If you are not a candidate, then you don't have any right. Unlike the previous provision of the Electoral Act that says anyone, any person. But the new amendment of 2020 now says it's only a candidate that has participated in the primary that can actually bring a pre-election matter against a candidate that has declared it by the political party. So it is issue of a law. You can't as a public interest lawyer now, go and sue over such matters, since the law does not confer any jurisdiction or any locus on you. So that is the position. So the present law, the present jurisprudence has actually limited those who can approach the court on pre-election issues.
So, Barrister Badr, from there, we're talking this local standing issue that the court also raised. And with the amendment to the electoral law, it's not just anybody, as Barrister Ubani said, that can approach the court. We've had these situations where Nigerians and public interest lawyers, whatever name we want to call them, feel that there are issues that they need to raise that are not being raised by possibly parties to some of these situations. How do we look around that? How do we work around that, given this judgment today? And where does this judgment today also fit in, given that it is specific to electoral matters?
Like my learned senior has said, it has the law. You have to put yourself within the perimeter set by the law. If what you are litigating upon falls within the four walls of the provisions of the law, then you have locus. If it is outside it, you don't have locus. And exactly what Dr. Ubani has just said is that the Electoral Act that has been amended limited the number of persons that can approach the court on issues that related to electoral matters. So if you are not a candidate, you don't go there. You don't have any business inundating the court with your grievances. So if your matter does not fall within the four walls of the law, then you are just a meddlesome interloper. You don't have any business approaching the court and wasting the time of the court.
Thank you very much, Barrister Badr. I'd like to bring Barrister Ubani back into the conversation.